Morning. So this is cause number 19023. You may notice that there's an empty seat here. Justice Gustafson is out of town and unable to be here today, but she is participating in the case and will be watching the argument and will, as I said, participate in the decision. 0223 is Vote Solar et al. Versus Department of Public Service Regulation. Our counsel ready to proceed? Who's going first? So you all three know you got 40 minutes.
Good morning, Justices. May it please the Court. My name is Zachary Rogala, attorney for the Montana Public Service Commission. With me today are co-counsels Al Brogan of Northwestern Energy and Jason Brown of the Montana Consumer Council. We'd like to reserve 10 minutes for rebuttal, and we're going to split the opening 30 minutes between the three of us. We're here today because we're asking you to affirm the Commission's decision. Our findings of fact were substantially supported, and our mixed questions of fact and law were correct. We appeal the district court's decision for one reason. The district court's decision results in a $2.6 million discriminatory overcharge for each QF that seeks to connect to Northwestern's system. That overcharge is illegal under both federal and state law. This issue is not academic. To the point, within weeks after the district court's decision, importantly, which resulted in rates higher than the Commission's previous 2012 stale rates, the Commission's phones lit up with developers asking if and when they could connect to Northwestern systems at the district court's inflated rates. For this reason, we appeal. I have three issues I'd like to cover briefly and then stand for any questions. First, this court should affirm the Commission's industry standard methodologies that it utilized to issue its avoided capacity and energy cost decisions. These industry standards were derived from well-accepted methodologies and thoroughly vetted in the contested case proceeding before the Commission. Both methodologies are mechanical. The Commission inputs data into an Excel file and it spits out a number. Those numbers inform the avoided energy and capacity cost decisions. This court should affirm and support that type of principled decision-making. Second, this court should affirm the Commission's carbon adder decision. Carbon should continue to be excluded from Northwestern's QF1 tariff because of its speculative nature. Even in 2017, in the dawn of the Trump presidency, it was clear that there would not be a carbon market in the foreseeable future. 3 years later, in hindsight, that decision is even more correct.
Mr. Rogala, I have two questions for you on that. First of all, the PSC's brief asserts that, as you just have, that the exclusion was based on the political reality of a speculative carbon tax and that the Commission's decision is supported by substantial record evidence. But the staff memo on the motions for reconsideration explains that record evidence did not support this exclusion. And my two questions are, one, can you point to specific evidence in the record that supports the Commission's decision? And two, can you respond to Vote Solar's argument that it isn't speculative because the Federal Clean Air Act requires regulation of carbon emissions?
Your Honor, to your first question, I would note in Order 7500D, the Commission cited to the notice in the Federal Register, which signaled, we think strongly, the Trump administration's decision to repeal the Clean Power Plan. That was in the record, and the commission relied upon that, and that is substantial supporting evidence. Regarding an implicit question in your question is, should this court review staff memos? And we think that staff memos are shiny, but they are distracting to the real issues. The real issues are whether the commission's decisions were supported by substantial evidence.
But the staff memo discusses the evidence in the record, and that's what I'm directing your attention to, is the evidence in the record that the staff noted and did not exist to support this.
I agree, Your Honor, but I think that staff are not the elected fact finders. The commission is, and so it's the final written decision by these elected finders of fact that matters. And in that decision, we support our decision based on the notice in the Administrative Federal Register that signaled the repeal of the Clean Power Plan.
The district court cited the Crazy Mountain decision by the commission and said that it was an arbitrary action to depart from that precedent without an adequate, at least without an adequate rationale. How would you respond to that?
Your Honor, two responses. One, there is no reason departure needed under waste management because the QF1 tariff has never included carbon. True, in QF proceedings between 3 and 80 megawatts in the Crazy Mountain Wind decision, it had included carbon. But that decision was based on the facts and record evidence before it, which was in the very beginning of the Trump presidency. QF1 decision decided a full 5 to 7 months later had a better record upon which it could base its decision to continue excluding carbon from QF1 tariff.
What was that record? I'm sorry. Specifically, what was the difference between Crazy Mountain in the record?
In the record, we have parties citing to the Federal Administrative Register notice, which indicates that there would be a full-scale repeal of the Clean Power Plan, which was the federal proxy upon which we based an avoided carbon adder in the Crazy Mountain Wind decision. Without the Clean Power Plan creating some sort of substantive carbon regulation, and it wouldn't be a carbon market, it would be carbon regulation. Without that principal foundation, the PSC had no foundation to include a carbon adder in the QF1 tariff.
Well, the second part of my question was, what about the Federal Clean Air Act? I mean, even though, the Clean Power Plan is a regulation, but Vote Solar asserts that the Clean Air Act requires it, and the commission seemed to account for that in Crazy Mountain Wind by deferring it until 2025.
That's correct, that even with repeal of the Clean Power Plan, we have the Clean Air Act, which regulates carbon. However, we did not feel that we had sufficient indications from the federal government that even though the Clean Air Act regulates carbon, that would have any tangible impact to ratepayers that would justify a speculative carbon tax. Instead, we felt a better balance between developers and ratepayers was to allow developers to retain the rights to their marketable renewable energy credits, which they can sell in the market today and which has a price point associated with it, as opposed to requiring customers to pay any sort of speculative carbon adder, which, again, right now still does not exist and it is not foreseeable in the near future. We felt that struck a better balance. Third, I'd like to touch briefly on the Commission's contract length decision. Similar to carbon adders, the Commission has been concerned with the speculative nature, the forecasting risk that exists with setting a contract price day one and then locking that in for a long term. To the point, some of the Commission's earlier QF contracts established 34-year contract terms in the early 90s. To date, those prices have been locked in, and to date, those have resulted in close to $1 billion in customer overcharges. This issue is real. That speculative nature led the commission to issue its notice of additional issues. And after receiving testimony from the developer's own witnesses, we concluded that a 15-year term was sufficient to balance the commission's responsibility to enhance the economic feasibility of qualifying facilities under the standard rate tariff, but also the real concern about leaving customers indifferent to the prices that they pay under the QF1 tariff. We assert that this decision was substantially supported, and to the extent it's an issue of law, we believe it's correct. And I need to make one point on this contract decision. However you reach your decision, we strongly request that it not be a bright line decision. The commission needs to retain its discretion to set contract lengths based on the record evidence before us in any given QF1 docket. Here's why this matters. When General Electric comes to Montana to build an 80-megawatt wind plant, they can finance it in-house, and they could possibly build it in-house. That's distinguished in kind from a CREP resource, or a smaller Montana-based resource, which does not have the intellectual or the financial capital to do it themselves.
So you think General Electric's gonna build QFs?
Your Honor, this issue is currently before us in, not with General Electric, but with another big boy who's in the room and is trying to masquerade as a qualifying facility.
So what about contract lengths for Northwestern's own alternative energy projects? And you got some pretty long contracts there.
That's correct, Your Honor, and it's important that the comparison between Northwestern Energy's own assets and the contract term for QF1 assets cannot be an apples-to-apples
Why not?
comparison. And the reason that is because the non-discriminatory requirement in federal code and regulation in 16 U.S.C. 824A3 sub B and in the CFR 18 CFR,
That seems to go
sorry.
the other way. I mean, the whole point is you can't discriminate against QFs. You got all these other projects out there that have longer contracts, or potentially longer contracts in Crazy Mountain. Wind and hydro both.
You're correct that Northwestern does, and they also have spot market purchases, which are intra-hour and hour. But here's the important part, the non-discriminatory provisions in federal law only apply to rates for purchases. Rates, not contract term. Contract term is a state law requirement where we are required to enhance the economic feasibility. And we believe that really depends on the record evidence before us, because
Doesn't PURPA say you can't set rates that are discriminate against alternative energy projects, particularly small ones?
correct.
So contract length is critical in terms of getting financing.
Your Honor,
Your big boys get financing, I agree, but we're talking about, in this case, we're talking about tiny QF projects.
and Your Honor,
Seem to be wanting to just squeeze out of existence.
And Your Honor, here's why contract length does not matter for the non-discriminatory requirements under PURPA. After the initial contract term is up, a QF retains the right to reconnect with Northwestern Energy's system at a then appropriate avoided cost. Importantly, if this state were to require non-discrimination in contract length, it would be the only state in the United States that viewed PURPA in this manner. And that is important because that would make us the outlier, because federal law is clear that PURPA requires non-discrimination in rates, not in contract term.
Counsel, before you move on, can you address when the PSC requested additional testimony on the issue of contract length, whether public notice was provided with respect to that?
Yes, Your Honor, and you should reject the developer's due process argument out of hand. In our procedural order issued in this docket, which lays out our procedural requirements, we put a notice of additional issues deadline. This is a standard practice which we have utilized for 20 years. We provided notice, and then we provided a substantial opportunity to be heard. We received testimony from a variety of parties, pre-filed written testimony, and then also received live examination testimony during the evidentiary hearing. But more importantly, to the point, we relied on the developer's testimony on this issue to establish the 15-year contract term. So we think there is no due process issue. Thank you. I'd like to yield the rest of my time.
Good morning. Al Brogan on behalf of Northwestern Energy. May it please the court. First, I'd like to provide a roadmap of what I hope to talk about today, but I realize I may not. I want to describe exactly what Northwestern is respectfully asking this court to do. I want to describe what this matter is about, both from an PURPA perspective and an administrative law perspective. I want to provide a very high-level description of what PURPA specifically requires. I want to discuss two important points about carbon. And then I would like to conclude with a brief discussion regarding the wholesale-retail distinction and what has been referred to as the symmetry issue. Except for the symmetry issue, Northwestern respectfully requests that you reverse the district court's order and affirm the commission's order. PURPA has generated much jargon, many new terms, and almost uncountable acronyms. Those of us that work in this area sometimes get...
Notice that.
And you'll appreciate, I hope, this, Mr. Chief Justice, is that those of us that work in it sometimes get involved in those and aren't as clear as we could be. Please, if I say something that isn't clear or that you don't understand, please ask me right then. My goal is to have a conversation with you and to provide clarity. From a PURPA perspective, this matter is simply about the determination of Northwestern's avoided cost. And I'll come back to that term avoided cost in a minute. And from an administrative law point of view, this is a straightforward analysis of whether the commission relied on substantial evidence and whether the district court could reweigh the evidence and substitute its judgment for that of the commission. Turning to the high-level view of PURPA. PURPA requires the utility to purchase the output that a QF wants to sell. It has no choice. Doesn't matter whether it needs that output, doesn't matter anything. It must purchase it. But there is a limitation in PURPA that protects consumers from being harmed by the utility purchasing the output from qualifying facilities, or QFs. And that limitation is that the utility may not pay more than the incremental cost of that same type of energy and capacity from another source. Now, incremental cost, that's what FERC has made into avoided cost. But the real point is, Northwestern can only pay the same amount that it saves elsewhere by purchasing from the QF. It's pure and simple that way.
So let's get right to that. In terms of capacity, if you guys are running everything full-blown that's in your own system, you're still short of peak demand capacity, correct?
Yes, Your Honor.
About 28%, correct? That's in the record.
I would say that's probably about right.
So that's a pretty big deficit. So at that point, right now, you guys are going out on the open market. You're buying from Talon, which is coal energy, right?
Yes, I believe so.
Pretty expensive.
Your Honor, I don't think I would concede that it's pretty expensive because it's at market-based rates.
Okay, fair enough. So the point is, you've got 28% of your capacity that you're you're going out on the open market at peak demands. And we're not talking about going and buying QF.
There's,
Alternative energies, you're going out on the open market to meet peak demands, 28% to meet 28% capacity shortage. So let's keep it real here. Talking about costs to Northwestern and consumers, that's pretty expensive. So wouldn't you want to increase your capacity?
Your Honor, when we start talking about capacity, we can get into a really esoteric and engineering argument.
Yeah, sure.
But what we're really talking about is energy that is there when the load is highest. Energy that is there when we need it. This time of year, that tends to be after dark on the very coldest days. And when we look at solar QFs, they produce nothing for us then. Similarly, if we look at wind during the extreme cold periods when we have a Alberta Clipper high that has come down, there's no wind blowing either. So when we talk about capacity, we have to talk about the reliability and the predictability of when that energy would be there. I can't just say, oh, I can go buy energy from anybody and that's going to solve my capacity problem.
So do you meet capacity when there is wind and sun?
There are,
Exclusive of those sources?
well, again, the point is, yes, I'm almost out of time already. Yes, we do. I would like to make really 2 points about carbon, because it seems to be a big issue. First, I think we would all admit carbon is an externality. Currently, Northwestern doesn't pay anything for carbon. We may all think it would be a good idea for carbon to be regulated, for there to be a carbon tax. But an externality is not a basis for avoided cost, because Northwestern cannot avoid any cost with respect to carbon by purchasing from a QF, because it doesn't currently pay any.
Well, so then you're willing to give back your carbon adders for all of your projects, the hydro projects. What do you get for that? $20 a ton?
Your Honor, I thank you, because that's my next point about carbon.
Good.
Our customers do not pay for carbon for any of Northwestern's owned resources. Rate making for resources is based on the cost of production, which is operating costs plus a rate of return times your investment. Those two combined equal a revenue requirement that then is divided by the billing determinants in a rate case. There is no place where carbon per se is added to that revenue requirement. The carbon that is often referred to for the hydros is basically maybe a carbon that was used as justification for them. But it is not something that customers pay. And it's something that we need to keep very much in mind. One thing I would add at the very last is that if the district court's order stands and it can reweigh the evidence and substitute its judgment for that of the commission, then no commission order will ever be final. And I don't think we want to create that environment. Thank you.
Mr. Brogan, I just have one last question before you sit down. Can you explain what I'm missing here is, so when Northwestern filed its initial biannual avoided cost application with the PSC in May of 2016, the proposal was a rate of between $34 and $44 per megawatt hour, and it did not propose shortening the contract. Is that correct?
When Northwestern made its initial filing, Your Honor, it basically set rates for contract lengths from 1 to 25 years and with or without RECs. And I think that generally the earlier ones were below the 34 level, and the higher ones had the recs and were for the long term, yes.
So that was correct?
That is correct.
So what, I guess I'm assuming, I mean, this was not just done willy-nilly. I mean, when Northwestern made that proposal, I mean, there was thought put into it.
Yes,
So I'm just trying to figure out what changed then now when we're, you're defending a shorter contract term and lower rates.
Northwestern has always been aware that there is the forecast risk, that you might have the wrong forecast for going forward. That risk exists in contracts, it exists in company-owned resources when you're trying to figure out, is this a good idea for the long term? More importantly, we had not seen at that point an inclination by the commission to reduce contract length. So we were just trying to keep in mind going forward with what had been being done for a long time.
Okay.
Thank you.
Good morning, Justices. May it please the Court. My name is Jason Brown. I represent the Montana Consumer Council. Our office is created in the Montana Constitution to represent ratepayer interests before the Montana Public Service Commission and the courts. And the MCC believes that the Commission's order in this case was supported by substantial evidence and is consistent with applicable law. PURPA requires consumer indifference, and it requires that. And that means that ratepayers don't pay more for the QF power than they would for power, the same amount of power from any other source. PURPA requires consumer indifference through the concept of avoided cost. And that means the incremental cost of just energy and capacity to the utility. Not the QF, not historic costs. This is a prospective, forward-looking exercise that the Commission routinely does. Now, having said that, I would observe that unfortunately in Montana, we do have a history of setting avoided cost rates that turn out to be too high based on flawed assumptions and forecasting. But there are three main issues, contested factual issues in this appeal: CO2 adders, contract length, and solar capacity values. With respect to CO2 adders, and I say adder because the appellees want to add this to the avoided cost of energy and capacity, if a CO2 adder is built into these QF rates to represent a cost that the utility never actually pays, then consumers are paying for a cost that is not being avoided. That's a violation of PURPA. The price paid for the hydroelectric facilities was negotiated. It was a purchase price that was actually paid by the utility, and it's true that it was rationalized partly based on CO2 avoidance, but an explicit CO2 adder was never included or approved in rates. And a price on future CO2 emissions was more speculative in this case than it was in that case, and is even more speculative today. PURPA, the law, does not require the Commission to include speculative costs in avoided cost rates. Renewable energy credits are defined under state law to include all of the environmental attributes. So it's reasonable to rely on RECs to account for CO2 avoidance. And it's the PSC's long-standing precedent to allow the small QFs to keep their RECs in these cases. With respect to contract length, the Montana legislature has repeatedly declined to fix the meaning of long-term, although it has repeatedly considered doing so, including in this most recent 2019 legislative session. Neither PURPA nor state law guarantee QF financeability, or even that every potential QF technology be made financeable. Energy on the market today is cheap, cheaper than it's been in a long time, historically. When a utility's avoided cost is low, fewer QF projects can be economically developed. We see this with Montana Dakota Utilities in eastern Montana. This is not a violation of PURPA. Now, state law uses terms like enhance and encourage, indicating a legislative preference for long-term contracts without defining long-term. PURPA, meanwhile, explicitly requires that QF rates cannot exceed avoided costs, and that contract terms, such as contract length, are left to the state regulatory authorities to determine. This is not just in Montana, this is true all over the country. Other states have gone as low as 2 years. 15 years is not uncommon. Our own state's renewable portfolio standard suggests 10 years for renewable contracts. The MCC urged 5 to 7 years in this case, so we see 15 years as somewhat generous. And we know that multiple renewable projects have been financed at 15 years in Montana. So this court should not legislate a contract length for small QFs when the legislature has clearly given the commission discretion to determine contract terms, including contract length. With respect to solar capacity contributions, the district court's finding that solar provides 36% capacity contribution in Montana is clearly excessive. The PSC found 6.1% because we often peak in the winter when the sun is not shining. Solar.
You also peak in the summer. I mean, we didn't, you look at that formula, there are peak hours in several months of the year, not just the winter.
There are, Chief Justice, and under what's called the SPP methodology, in those years, that would be the month that would be the basis for the capacity contribution. But in many years, often, we do peak in the winter. We're a dual peaking utility. And although solar might do great things in the summer, another resource will be needed during those winter peaks. So if the district court's order stands, we'll be paying the QFs for capacity that they're not actually providing during those winter peaks when they do happen. And we'll also have to pay for another resource to actually show up and provide that capacity.
And I'd like to just follow up on that because Mr. Rogala mentioned that these methodologies are, you basically take the data set, you plug in the numbers, and it spits out a result. And both Mr. Beach for Vote Solar and, I mean, it seems like there was a lot of discussion about this SPP methodology, and he plugged in the numbers, and even with the 60% exceedance, came up with a solar capacity value of 39%. But Mr. Bushnell then went back and used the same 10 years, if I'm correct, used the same 10 years of solar data in the docket and 10 years of the Montana load data and came up with 6.1%. Am I comparing the right data that they both used? Did Northwestern and the PSC in fact come back and look at the summer months as well?
Yes, Your Honor, there was a dispute in this case about how to apply the SPP methodology, and there has been in a number of these cases, but the commission has been consistent in selecting the single peak load month under that method. And it's my understanding that the appellees can correct me that they used multiple months to achieve the result that you mentioned. So I guess I just ask you to remember that if you set these rates higher than the incremental cost of just energy and capacity to Northwestern Energy, or if you assume that these QFs are going to provide more capacity than they actually do, then ratepayers will overpay for this power in violation of PURPA.
Do you have a thought on Mr. Rogala's statement that that amount is about $2.6 million per QF contract in overcharge?
Your Honor, I've not personally confirmed that number, but that sounds about right. So I'd ask this court not to reweigh the evidence, as did the district court, but rather affirm the commission's rate-making determination. Thank you.
So you all have got 7 minutes, 36 seconds left.
Good morning. May it please the court. Jenny Harbine on behalf of Appalese. I'll reserve 7 minutes of argument time for counsel for intervener Wind Data. This case is an appeal of a decision that effectively killed the development of small renewable energy resources in Montana. There's
Ms.
several.
Harbine, right on that point then, can you speak to Mr. Brown's point that there have been QF projects financed at 15-year contracts?
There have been no small QFs, which are the 3 megawatt projects at issue in this proceeding, that have entered contracts and been developed in the time since the commission issued the final order in this case.
Okay, but just speaking more broadly, have there been either QF, meaning up to 80 megawatt QFs or the small QFs? Have there been projects financed at 15 years, whether before or after?
There is no evidence in this record that that has happened. There are several issues in this proceeding, but they all have one thing in common. At every decision point, the Commission took action to reduce compensation and reduce certainty for small renewables developers. And the result was a drastically reduced standard rate and drastically reduced contract length that have made it impossible for these resources to compete in our state. And this result is directly contrary to PURPA, which requires the Commission to encourage independent development of small solar or renewable energy resources by establishing reasonable and non-discriminatory terms. I'm going to begin by addressing the standard rate issue, and then I'll turn to the contract lengths. Now, in establishing rates for QF generation, utility commissions apply this PURPA framework. And PURPA is supposed to allow independent resources an opportunity to compete. This is important because a utility has the incentive to prevent independent resources from displacing the company's own resources, for which it earns a guaranteed profit from its customers. But while this is the utility's incentive, under PURPA, a utility's customers, and therefore the Public Service Commission, should be indifferent as to the source of their energy. And PURPA achieves this by mandating compensation for QFs that equal the costs they allow the utility to avoid. Customers in this way pay no more or no less for QF generation than they would otherwise pay. Here, the Commission undermined the PURPA framework by dramatically undervaluing the capacity value of solar QFs and the energy value for all QFs. QFs that reliably operate during periods of high customer demand allow the utility to avoid investments to build new capacity or purchase capacity. Mr. Brogan described this as energy being there when Northwestern Energy needs it. And you also heard Mr. Brogan concede in response to a question from Justice Shea that Northwestern needs capacity in the winter when the wind is blowing and in the summer when the sun is shining. And this is the most important fact on this issue, which is that Northwestern has capacity needs in both the winter and the summer. And they have peak demand in both seasons. When we're talking about peak demand, these are the hours when Northwestern's customers are using the most energy. And you might think in Montana that that's primarily in the wintertime. But Northwestern's data shows that in about half of the years studied, peak demand actually occurred in the summertime. And Northwestern conceded in the record that there's a trend toward more summer peaking years. Also in the broader region in which Northwestern makes energy transactions, the hours of the very highest customer demand are in the summertime, not in the winter. And this is a relevant factor because the Commission itself said that it's regional demand that drives Northwestern's capacity needs. But the Commission's methodology for calculating the capacity value of solar resources almost completely disregarded summertime demand. Instead, the Commission focused on just a handful of hours that reflect the coldest winter evenings over the period of a decade. And the problem with this approach is that Northwestern actually needs capacity over a much broader set of hours that includes many hot summer hours when demand for energy is high. So for Northwestern, both summer and winter are important.
Ms. Harbine, so given that the standard of review requires us to look at substantial evidence in the record, and not being an expert in this area, I want to know if you can clarify. It seemed to me that in response to Mr. Beach's criticism on that point, both the Public Service Commission staff and Northwestern's witness, Mr. Bushnell, went back and looked at the data and still did not come up with that same capacity percentage that you all proposed. Can you address that?
Yes. Mr. Beach critiqued the application in this case of the SPP methodology by pointing out that Northwestern and the commission had aggregated Northwestern's peak load hours over a 10-year period, which put those very high yet infrequent wintertime spikes in demand at the very top. Now, they continued to do this when they alleged in their order on reconsideration that they actually considered summertime demand. They still aggregated those hours, which elevated the importance of the wintertime peaks over the summertime peaks.
But that seems like a pretty, that's a methodology that is not a novel methodology used, the SPP, as I understand it. And the commission did not accept Northwestern's 85-10 percentage or what have you, but adopted a lower, or the 60. So I guess the question is, the substitution of a judgment over the methodology and the numbers plugged in by a court rejecting what the PSC did here. That's what's really troubling me about this capacity contribution issue.
The question here is whether the application of the SPP methodology to Northwestern's capacity needs was arbitrary. Now, I'm not saying that the SPP methodology has no legitimate application, and it has a very specific application for the Southwest Power Pool that developed that methodology. But here we have a utility that Mr. Brown this morning told you was dual peaking. It peaks in the summer, it peaks in the winter. And so the very simple question on the capacity issue is, was it arbitrary for the commission to overlook those summer peaks and focus exclusively on the winter peaks?
Back to Justice Baker's, or following up on that though, in terms of the standard of review, it just seems to me that there's a certain amount of, okay, on the one hand, reviewing and making a determination whether the decision was arbitrary or whether the factual findings were supported by substantial evidence, versus then taking it a step beyond that, and instead of sending it back to the PSC to a court engaging in essentially rate setting and contract terms. It seems to me like that's kind of swerving out of their lane a little bit.
This court doesn't need to engage in rate setting. This court needs only to reference the record evidence. Here there are two relevant factors: Northwestern's wintertime demand and Northwestern's summertime demand. Overlooking one of those relevant factors rendered the commission's determination arbitrary. So then the question becomes, what does the court do about it? In the record, the only evidence put forward on the appropriate way to account for summertime demand is the evidence put forward by Mr. Beach, which found a 36% capacity value for solar resources.
But just finding that some evidence is not supported in the record does not necessarily mean, is the correct response to remand, or is it the correct response to just defer to evidence that what essentially is a fact finder here has rejected?
We have here a tariff decision by the commission that it makes periodically. Usually every 2 years. We've now had a 3-year gap in the decision. My clients are in a position of having to chase decision after decision by the commission that's unsupported by substantial record evidence. A remand to allow the commission to re-engage in fact-finding when a record is already before this court that supports an appropriate conclusion would exacerbate the already untenable delay that renewable energy developers have had to face in the state of Montana. And so we'd urge this court to uphold the remedy with respect to capacity as well as the other issues that the district court ordered in its modification order. Pursuant to that order, the commission actually issued an order, it's Order 7500E, which appears as Appendix E to Northwestern's brief. And that order directed Northwestern to submit a modified tariff that addresses and fixes all the issues that we're discussing here today, including capacity. Now, Northwestern didn't submit that modified tariff because a day before it was due, this court issued a stay order. And we would urge the court, now that you have the merits of this case fully before you, to lift the stay so that Northwestern can submit that modified tariff that addresses the issues that we're addressing, including capacity. I'd like to turn to energy costs, and these are different than capacity costs, which are, as I discussed, the upfront costs to acquire or purchase capacity. Energy costs instead are based on Northwestern's costs simply to buy energy on the market or to operate its resources in any given hour. So anytime Northwestern is purchasing energy from a QF, it is avoiding those costs to buy energy or operate its resources. And the first way in which the commission undervalued energy costs, as we've discussed, is by assigning a value of 0 to carbon dioxide emissions that would be avoided by renewable energy resources. And the idea behind compensating clean energy resources, whether they're wind or hydro or solar, for avoided carbon costs is that future regulation of carbon dioxide emissions will make Northwestern's operation of its fossil fuel resources more costly. And because of this, it's industry standard to compensate qualifying facilities for these carbon costs they allow the utility to avoid. And beginning in 2013, the commission consistently has included Northwestern's projection of future carbon costs into the rates for qualifying facilities, and as the Chief Justice noted, also for utility-owned resources.
Could you address the argument that the allowance for the QS to keep the RECs makes up for that?
This is a post hoc argument by MCC that, in addition to being illegitimate, is incorrect. MCC's position is that by allowing a QF to retain the value of a renewable energy credit, it somehow allows for the commission to avoid including carbon costs and energy rates. But the commission itself, in the underlying proceeding in the order on reconsideration at paragraph 37, explained that carbon costs are an inherent component of energy costs that are separate and apart from the value that RECs entail. So under this court's Montana-Dakota Utilities precedent, it would be an illegitimate reason for upholding the commission's decision on carbon. Because carbon costs are an inherent component of energy costs, PURPA mandates that they be included in energy rates. The only way the commission could legitimately avoid compensating QFs for carbon is by finding that those costs will be 0 for the next 15 years. But that's not what they found, and that's not what they're arguing here today. Instead, they're saying those costs are uncertain. No party testified that those costs will be 0 for the next 15 years. And the record includes industry projections supporting the inclusion of carbon costs. As the commission had acknowledged in case after case prior to its decision in the underlying proceeding, uncertainty in future carbon prices is not the same thing as 0 carbon price. And it rendered that decision beginning in the hydro docket when it accepted Northwestern's inclusion of carbon prices in that case. And in fact, the commission addressed a nearly identical record to the one that's before this court in the Crazy Mountain Wind decision. It issued that decision just months before its decision in this case, but it treated those circumstances very differently. And there's been a little bit of sleight of hand this morning in talking about the Crazy Mountain decision and saying somehow this repeal of the Clean Power Plan that postdated that decision renders the two records different? It did not. If you look at the order on reconsideration in the Crazy Mountain Wind decision at paragraph 40, the commission explicitly considered or presumed that the Clean Power Plan would be repealed. In looking at the results of the 2016 presidential election, the commission pointed to the promises of candidate Donald Trump to eliminate the Clean Power Plan as justification for its decision in that Crazy Mountain case. But what it did in Crazy Mountain was very different than what it did in the underlying proceeding. It decided that that uncertainty created by the Clean Power Plan repeal justified delaying the onset of carbon pricing, not eliminating it altogether. The commission staff specifically identified the commission's arbitrary reversal problem in recommending that the commission include avoided carbon costs in the QF1 tariff. And I'm quoting from page 19 of the staff memo on reconsideration, which is at tab 141 of the record. Quote, "The commission's decision in the final order reduces to a case of the commission changing its mind in an arbitrary manner." Staff was correct. Nothing in this record supported the commission's decision in 2017 that carbon dioxide costs in 2032 would still be zero. The commission's decision should be remanded for inclusion of carbon costs in the standard rate. The second flaw in the commission's avoided energy cost calculation was its undervaluation of costs in the years before 2025. And in the interest of time, to ensure my colleague has an opportunity for full argument, I intend to rely on our briefing for this issue, but I'm happy to answer questions. I'll turn now to the contract length issue. The commission reduced the contract lengths available to QFs from 25 years to just 15 years. The issue of contract length is governed in Montana by statute. It's Montana Code 69-3-604, subparagraph 2. And that statute requires the commission to establish long-term contracts in order to enhance the economic feasibility of qualifying facilities. Long-term contracts.
What about,
required.
and I apologize to all three of you that I don't recall who made the argument, but that the legislature has not defined long-term. I mean, 15 years could be considered a long-term contract.
Because the legislature hasn't defined long-term, it's up to the commission to grapple with what it means to enhance the economic feasibility of qualifying facilities. And the problem in this case is the commission didn't undertake that inquiry. They point to expert testimony that observes that although renewable energy projects are inexpensive to operate, they require a significant upfront investment to build. And so their financing requires sufficiently high rates over a sufficiently long term in order to allow them to pay off that investment and secure that financing.
There's quite a bit of testimony in the record about a 15-year contract length being the minimum. And there was a lot of, your witness certainly recommended higher than that. The staff recommended 15 to 20 years on the reconsideration, but the commission did recognize that a 10-year term was not supported by the evidence. How does the record not support a 15-year determination when so many witnesses talked about that term?
Because the question of whether a 15-year term is sufficient to enhance the economic feasibility of QFs, which is what the law requires, is inextricably intertwined with the price term. And none of the testimony in the record supported 15-year contracts in all cases, and certainly not at the low standard rate adopted by the commission.
Well, but there are two separate issues as presented to us and presented to the court. So, they're not necessarily intertwined. I mean, if you've got a higher rate, that, it seems to me like you've got kind of sliding scales. A higher rate may justify a shorter term in terms of what you're looking at ultimately is to encourage the development and in that vein, to encourage financing or to make financing viable.
I couldn't agree more, and the problem is the commission didn't address that question. It never looked at whether this 15-year contract is sufficient in light of the low standard rate it adopted concurrently. Now, the appellants pointed to the MCC's advocacy in the proceeding below about contract lengths in other states, but the commission itself found this testimony unpersuasive, specifically because it didn't include any evidence about how those shorter contract lengths actually affected QF development and their ability to obtain financing, which is the key question. Mr. Regala today said, this issue is addressed because a QF retains the right to sign a new contract at the end of the contract term. But again, this doesn't address the issue in the statute, which requires the commission to give QFs an understanding at the outset of a long-term contract, what those prices will be in order for them to secure financing.
So, counsel, if those two factors are intertwined, inextricably intertwined, as you've said, how are we supposed to make a decision based on the record rather than remand it for consideration in front of the PSC?
Because the commission lacked substantial evidence for its decision, and by the way, the commissioners admitted that the evidentiary record was weak, because they lacked substantial evidence on that decision, the decision should be reversed and the prior 25-year contract length should be retained.
So what you're asking to follow up on that is that each one of the points that you take issue with, we should adopt your argument and not send it back to the commission. I mean, is there a middle ground? In other words, shouldn't the commission look at all the factors? If we decide that what it did does not allow for this economically feasible project to develop, do each of those points have to be reversed by this court? I mean, how are we to make that determination?
The most straightforward remedy in this case is to lift the stay and instate as a permanent remedy the remedy ordered by the district court in its modified order that would reinstate the commission's order 7500E, which would require Northwestern to fix these issues in a modified tariff. And I understand the concern that's baked into your question, Justice Baker, that you want the commission in the first instance to be addressing these issues. And while I understand that concern, we are in a situation where time is of the essence. No QFs have been able to be developed in the years since the commission issued its final order in this case. And this court can remedy that injustice by lifting the stay today. And in addition to creating opportunity for economic development for renewable resources at issue in this case, this needed direction from the court will provide an important course correction for a commission and a utility that continue to make decisions about Montana's energy future. Thank you.
Good morning, Mr. Chief Justice, members of the court. Monica Trinnell on behalf of Wind Data and Jaffe Wild, developer of wind resources in Montana. Northwestern's resource stack consists of the resources that Northwestern owns: Colstrip, Dave Gates, Spinenkop, the hydros, on which Northwestern earns significant profit, whether they are operating or not. Northwestern's resource stack also includes our wind farm, small hydros, small solar, on which Northwestern earns no profit. Those resources exist in Montana only because of the Public Utility Regulatory Policy Act of 1978, PURPA. PURPA's mandate is that the value for the electricity produced by our wind farm is analyzed with the same methods that are used to value electricity from Northwestern's owned resources. Non-discrimination. In this case, before you, the Commission clearly, unequivocally acknowledged that it discriminated in removing any value for carbon regulatory costs from our wind farm, and in reducing the valuation period from 25 years to 15. Look at paragraph 130 of Order 7500C, paragraphs 81 and 111 of 7500D. The Commission's admission of discrimination is unequivocal. The sole justification that the Commission gave for its acknowledged discrimination in this case was that someday, in the future, it would apply this new methodology to Northwestern's resources down the road. Northwestern challenged that, and the district court reversed it. That question is not before you now. As this case is postured before this court, you have unequivocal, acknowledged discrimination by the Commission and no defense. No defense that the Commission itself recognized was necessary for the discrimination on the front end. On that basis alone, this court can reverse Order 7500C and D and implement the tariff that the Commission calculated in compliance with the district court's first initial order on April 22nd. It's Table 4 of our Appendix Document 5. It includes the calculated rates by the Commission for this tariff that includes carbon and is at 25 years. The court can ask that that be implemented immediately and be done.
Wait a minute. The anti-discrimination provision of PURPA is just one piece of the puzzle. It's not the whole puzzle, right? There also has to be a determination that this process of calculating these rates do not increase the cost to the ratepayer. That's another part of the puzzle. And so there seems to be this big picture problem here that, yeah, you can poke a hole in the carbon decision of the Commission, or you could poke a hole in the methodology for peak, in all these things. But the bottom line principle of PURPA, you can't increase the cost to the ratepayer, correct?
The bedrock principle of PURPA, as acknowledged since the 1982 decision in FERC v. Mississippi until last summer's decision in Winding Creek v. Peterman, is non-discrimination. And the no harm, the hold harmless to consumer, is balanced with that. So the avoided costs have to not discriminate. The methodology, and the Commission says it's clear as day in its order, the methodology has to be the same. So when the Commission...
But it's not to the exclusion of the cost to the consumer. I mean, you have to look at both.
You have to look at both and balance both, and the methodology that the Commission uses, the Commission included a carbon regulatory cost for Northwestern's resources, $250 million that Montana is paying every day today, is in our rates. The Commission gave that carbon regulatory anticipated cost to Crazy Mountain Wind, a docket that happened at the same time as this docket. So the question, Justice Rice, is how do we not discriminate, and how do we ensure that customers aren't paying more than they ought to be? The Commission has embedded a carbon regulatory cost in Montana's rates when it approved the hydro acquisition. The Commission says, well, we ought to be able to deviate from that. They told you that when they deviated for these small projects, and they kept it for Crazy Mountain, contemporaneous proceedings, they said, we are discriminating. But it'll be okay, because we're going to do it later to Northwestern too. But now they're not going to be, because that's gone. So all you have is discrimination, period. And this court can end its decision there. The stakes are high. 2017 was the largest and most expensive fire season in Montana since the Great Burn. Wind Data is asking you to take the commission at its word. It discriminated. Absent any defense for that, this court must reverse Orders 7500C and D, implement the tariff that's found at page 4 of our appendix document 5, and let Wind Data get back to work building some wind projects in Montana. Thank you.
Thank you, council. Thank you to all council. That concludes. the
Rebuttal?
We still have
I'm sorry,
7 minutes and 36 seconds.
36 seconds, I apologize.
Mr. Chief Justice, I'm going to touch on just a couple of points, and then Mr. Regala will be addressing the other points. First off, both of counsel for the appellees have asked you to lift the stay order. We fervently request that you do not. Lifting the stay order would expose Northwestern's customers to a land rush for new QFs, especially solar ones. Ms. Harbine said that carbon costs are an inherent part of the energy price. I respectfully disagree. As I explained, carbon is an externality. It's not currently priced in. It may be someday, but I don't have as clear a crystal ball to say that future carbon regulation will charge for it, as she did. I think it's important to look at what the Commission said when it declined to include a carbon price. And this is at paragraph 75 of Order 7500C. The Commission will not include a carbon dioxide emissions adjustment to the avoided cost estimates used to set QF1 standard rates. The Commission is persuaded by MCC's advocacy that including carbon costs, which are not currently priced and for which future pricing is highly uncertain in avoided cost estimates, unnecessarily puts customers at risk. The guiding principle of PURPA is that customers are to be no worse off with QFs than they are without. Please reverse the district court's order and uphold Orders 7500C and D.
So I got a question in that regard. What if we lift the stay as to 7500E and ask the PSC to follow through on their order to Northwestern to file a new proposal?
Your Honor, if the tariff that's attached to 7500E goes into effect, then those become the lawful rates.
I understand that. What, wasn't very clear on my question. My question is, what if we just ask the commission to proceed, we hold the stay on the tariff that the court required and ask Northwestern to go ahead with that process that the commission had asked for?
Your Honor, I think that it's important to note that some of that would be stale at this point, and there is currently a new QF1 docket before the Commission, where they will be looking at all of the issues again. Interveners in the QF1 docket filed testimony last week. I don't think there's any way to go forward with Order 7500E without changing the rates and putting customers at risk. Thank you.
I'd just like to respond to Justice Baker's question about capacity, because we have not spent enough time on this issue, and this is fundamental. The PSC correctly applied the SPP methodology. The MEIC did not. Two reasons you can be secure in that statement. First, we're continuing to apply the SPP methodology like we did in 2017 today. We got it right because it's a manual and it's an Excel file that you put raw data into.
So, just like any statistic, it depends on the data you put into it. So, back to this capacity issue, if you're not even looking at summer-related capacity,
And
doesn't that skew what comes out the other end of your data?
correct, but the developers are wrong. Because we did. We looked at 4 summer peak months and 6 winter peak months. Here's how they mistaked the calculation. You have 10 years. Select the highest peak load month in each year. In 4 of those 10 years, it was a summer peak. In 6, it was a winter peak. You take a selection of those hours in that peak load month and you aggregate them. Then you run a 60th exceedance methodology on that entire stack. That results in a 6.1%. How the developers misstated the process is instead of aggregating them, they ran an exceedance on each of those 10 months. And then they averaged them, and that results in a 36% capacity factor. And as the MCC noted, that is excessive beyond belief because winters matter in Montana, and the solar contribution factor that they can provide in Northwestern system is 0 when Northwestern system peaks during cold winter nights.
So your position is that the commission, contrary to Ms. Harbine's argument, did not ignore the summer peaks?
Correct. We, in fact, relied upon 4 summer peaks.
Mr. Regala, in terms of the, I got conflicting answers in terms of the contract terms. Mr. Brown had noted in his argument that there have been QF projects financed, unless I misunderstood, at 15 years. And then Ms. Harbine said there's not, or maybe that it's just not in the record. Is there evidence in the record of QF contracts being financed at 15 years? And if so, where can I find it?
You won't find it in the record because this was a 2017 record. But offhand, I do know that the South Peak project has been, I believe, and I would defer to the developers or the utilities and the developers on this because I'm in the agency and don't have on the ground evidence. But I believe the South Peak project and also some large QF projects, but that is outside the record evidence, and I agree with Ms. Harbine on that.
Okay, thank you.
One last point is that we're respectfully asking this court to switch the spotlight from alleged commission discrimination to discrimination by the district court. Because to include a carbon adder, to include a 36% capacity value, to include an ICE proxy unit, that is discriminatory because that does not leave customers indifferent to price. For these reasons, we request this court to affirm the commission's decisions because after reading our initial 140 paragraph order and the 120 order on reconsideration, it should be clear we did our job. And to do otherwise requires a $2.6 million overcharge for each QF1. Thank you.
So I got just one more question,
Chief, you didn't want rebuttal, remember?
right, now you know I want more rebuttal. Just for my own mind, when we're talking about 6% capacity versus the 36% capacity argument, what you're talking about is the percentage of capacity you need at peak. Is that right?
No, Your Honor. So what we're talking about is avoided energy is 1 point. Avoided capacity is the second.
Right.
There's 2 calculations in capacity. One is you establish the correct capacity resource, and here it's an arrow unit. Then you determine the contribution factor of a specific type of resource that can be avoided of that proxy. For solar projects, it's that 6.1%. So you multiply that 6.1 by the avoided fixed costs of that proxy.
Thanks. Believe it or not. Okay, now we're going to conclude the